content. What the court doesn't explain is how that's different from plaintiff's claims in this case, except to say that somehow paragraph 53 has become part of our constitutional definition, and that seems to be problematic for the court. But aside from that, there seems to be no difference, Your Honor. If the court has no more questions, I'll defer to my co-counsel. Thank you.
May it please the court, my name is Neil Weir from the Jerome N. Frank Legal Services Organization, and on behalf of plaintiffs, I'll be discussing the issue of justiciability. We agree with the trial court's determination that plaintiffs' claims are clearly justiciable under long-standing Connecticut precedent. And having won on this issue below, we would normally not stand to address a question that was not raised on appeal. But given the extensive treatment of this issue in the state's brief, I would just like to briefly address how this court has applied its justiciability doctrine to claims brought under Article 8, Section 1, and also discuss how the highest courts of 18 of Connecticut's sister states have found it both within their judicial role and their judicial capacity to adjudicate similar claims. I'll then reserve the remainder of my time to rebut the state's argument that this court should break with its long-standing precedent and the overwhelming majority of sister state decisions to nonetheless find plaintiffs' claims non-justiciable.
When the trial court returned at the end of its memorandum to issues of prudentiality, prudence in a court getting involved in the situation, do you claim that the court was returning to the issue of justiciability and coming out with a different result?
To some degree, yes. We believe that prudential concerns are most appropriately part of this court's justiciability analysis under the Baker v. Carr test. Of course, this court can also consider prudential considerations as it fashions a remedy, as it did in both Horton and Sheff. But to use prudential cautions to refrain from recognizing that Article 8, Section 1 provides a constitutional floor of educational opportunities, below which the state is in violation of its affirmative constitutional duty, we do not believe is appropriate. For the legislature retains broad discretion in acting anywhere above that constitutional floor. So these prudential concerns we do not believe should influence the constitutional interpretation. Indeed, the Geisler analysis that you spoke of earlier does not include these types of prudential considerations as part of the tools for constitutional interpretation. As an initial matter, this court's justiciability doctrine recognizes that defendants face a high bar to showing that plaintiffs' claims should be found non-justiciable under the political question doctrine. As this court noted in Seymour, when considering whether a case raises a political question, courts should place a heavy thumb on the side of justiciability, and the court should view plaintiff's complaint in the light most favorable to finding plaintiff's claims justiciable. In Sheff, the court also stated that every presumption is to be indulged in favor of subject matter jurisdiction. Further, as the court noted in Nielsen, unless one of the Baker factors is inextricable from the case at bar, there should be no dismissal for non-justiciability. When it comes to claims brought under Article 8, Section 1, justiciability is not a matter of first impression for this court. 30 years ago, in the Horton decision, the court recognized that the General Assembly's education finance legislation was not appropriate legislation to implement the state's constitutional duties under Article 8, Section 1. And the Sheff Court reaffirmed this approach, holding that just as the legislature has a constitutional duty to fulfill its affirmative obligations to Connecticut school children, the judiciary has a constitutional duty to review whether the legislature has fulfilled that duty.
But isn't it true that in Sheff, the court never reached whether or not there was a justiciable issue under Article 8, Section 1 alone, because they coupled Article 8, Section 1 with Article 1, Section 20. And that was the issue that was decided in that case.
Yes, the claims that the court considered in Sheff were both under the Education Clause and under the Constitution's equal protection clauses.
But to the third count in your complaint in the trial.
Yes. But the justiciability analysis in the case was very specific as to Article 8, Section 1, examining the text of that provision and finding that the phrase appropriate legislation in Article 8, Section 1 does not deprive the court of the authority to determine what is appropriate. So we believe that this court's holding in CCJEF should be dispositive to the first factor in the Baker v. Carr analysis of whether there is a textual commitment to the legislature under Article 8, Section 1. Furthermore, this court's decisions in Nielsen and Pellegrino, the foundational justiciability cases, both cite to judicial enforcement of Article 8, Section 1 as a paradigmatic example of proper judicial enforcement. Indeed, in Nielsen, the court said that the court has authority to direct legislative reform of school financing statutes. That's all plaintiffs are asking for in this case. This question of...
But how do you know that that isn't based upon the equal protection argument rather than the standalone Article 8, Section 1?
Well, we believe that this court in CCJEF, the justiciability analysis, was separate from the analysis simply on the merits of whether the court, in terms of the remedy that the court should provide, or whether the state is in constitutional breach of its affirmative constitutional duty. So the question of whether the legislature has unbound discretion, as the state seems to claim, free from judicial review, is a question that we believe was foreclosed under the CCJEF holding, that while the legislature has a duty to fulfill its affirmative constitutional duty, it's the court's role to determine whether the legislature acts within the constitutional principles established by Article 8, Section 1. While CCJEF and Horton may not be dispositive as to some of the other Baker v. Carr factors, we still believe they're highly probative to that. On the question of judicial role, it seems that this court's strong statements in CCJEF apply equally to the claims the plaintiffs have raised today.
How do you explain Nielsen, then, where there's been no action by the legislature? And we've found that there's that was non-justiciable.
Well, indeed, in Nielsen, the court found that those claims were non-justiciable because there was a textual commitment to the legislature, unlike in this case where the court has recognized that there is no such textual commitment in Article 8, Section 1, indeed holding the exact opposite in this case's CCJEF decision.
Well, if you take a look, it's second sentence of Article 8, Section 1 says the General Assembly shall implement this principle, being the first sentence, by appropriate legislation. Why isn't that a commitment to the legislature?
Well, again, as this court stated in CCJEF, this court's holding that appropriate legislation is the hook within which the courts can look to for judicial review. But even if this text did not contain the word appropriate, as this word is lacking in many other similar constitutional texts like New York or South Carolina or other states that have very similar language, those courts have nonetheless recognized that when it comes to affirmative constitutional principle, affirmative constitutional rights, that the court has a duty to enforce those rights. So even if the word appropriate was in our text, as it is, which makes it a stronger case for us, and even if this court were to accept the state's seeming invitation to step away from its very direct holding in CCJEF, we believe that in looking to the actions of other states, which have considered similar language, that this court should follow the majority of those sister states, 18 in fact, which have found very similar claims to be justiciable. And this brings me to talk a little bit about some of these sister state decisions. So while the state seems to argue that it's inextricable that any of the remaining Baker v. Carr factors are inextricable from the case at bar, the overwhelming majority of these sister states demonstrates the otherwise. The fact is that 18 of these courts have already adjudicated similar claims, finding it well within their judicial power, both in terms of their proper judicial role and within their judicial capacity. Indeed, as the Kentucky Supreme Court stated in Rose, to allow the General Assembly to decide whether its actions are constitutional is literally unthinkable. And with respect to judicially discoverable and manageable standards, the Texas Supreme Court explained in its Neely decision